When discussing the legal aspects of law enforcement, there's a lot of attention given to the Bill of Rights, specifically the Fourth and Fifth Amendments that heavily govern common police practices such as searches and seizures and interrogations of suspects. However, we also need to talk about the 14th Amendment and the concept of incorporation. The 14th Amendment includes 5 sections, but let's just talk about the first. And in particular, we're going to look at the third clause of the first section. We look at the language, nor shall any state deprive any person of life, liberty, or property without due process of law. This is where the concept of incorporation comes into play. Originally, the Bill of Rights applied to the federal government. Slowly, though, the Supreme Court began to interpret this clause in the 14th Amendment to guarantee the rights enumerated in the Bill of Rights against infringement from the various states, thus incorporating the Bill of Rights to the state level. So let's look at an example. The exclusionary rule was originally interpreted by the Supreme Court in a case called Weeks versus United States in 1914. With that ruling, only when federal law enforcement officers obtained evidence illegally would it be suppressed. Only then, it would only be suppressed in federal prosecutions. It wasn't until Mapp versus Ohio in 1961 that the exclusionary rule was incorporated to the state level. After Mapp, illegally obtained evidence was suppressed regardless of what agency obtained it. Incorporating rights is very significant because the majority of law enforcement is done at the state or local level. Rights that only protect you from the federal government don't protect you very well.